give us a heads up first.
Thank you, Mr. Chair. So, councillors, we've got a pre-work submission here post the workshop that we had. Understand not all councillors were present at that workshop, but we gave the draft a pretty good lashing. It is comprehensive. We have moved a few things around and tightened up some of the words as councillors asked. For those councillors who were curious, the draft was up on the website, so we have had all our TAs we've circulated it, to our TA staff, to our iwi partners, to a number of sectors who have wanted to get their hands on our submission. So it is the draft, noting that we're having the final before you. I do just want to highlight paragraph 6 of the submission, which is on page 2 of the submission.
Page 39 of the agenda.
Thank you, my lovely assistant. Page 39 of the agenda. Where, in response to councillors' concerns at the workshop, who said, look, the submission sounds like we are tearing down, not being very constructive, and just put that paragraph in there that says, look, the submission is comprehensive. It does identify a lot, but that's really because we want to focus on improvement. We don't want the ambulance at the bottom of the cliff once we've got the legislation saying, hey, this doesn't work, it's not going to work. In our experience, it's a real challenge. So we have put that in there too, and it's not a caveat at all, but it's just an explanation that what we are trying to do is get something that's workable for everybody involved, not just ourselves, but the people we know with our experience who will have to navigate through things, and it's not always the easiest. That's what we've tried to do. So I'll pass over to Miffy and Katrina, who'll take us through. We've also got Brent and Mr. Brocklesby, Mark Brocklesby, live and in person. This is exciting for many of us who haven't seen him for a while, who is our technical expert and will be able to respond to questions. But Katrina will first take us through key points and key changes.
Thank you, Tracy. Thank you, Mr. Chair. So we will keep it brief this morning and just focus mostly on the changes we've made following councillor feedback at the workshop, and also some minor corrections that are still needed through the submission. Before I get to that, I just wanted to note up front that since the workshop, we've also had the opportunity to read some other organisations' draft submissions, and the WRC draft is well aligned with the drafts of Te Uru Kahika, who represent the regional sector, and Tai Tuara, which both raise some very similar key issues and recommendations to the bills. So this slide in front of you summarises the key points in part 1 of the submission. This part of the submission is just very high level comments on resource management reform in general. I won't read them out for you, but those are the key topics. Next one, Brooke. I'll also skip over this one because we covered these in some detail in the workshop, but these are the, oh sorry, we've skipped one ahead. Go back a couple. Yeah, thank you. So this one is the key points in part 2 of the submission. So part 2 covers clauses that are common across both bills. So it's a bit more detailed topics than what part 1. Next one, please, Brooke. This is the slide that I will focus on. So this is what we have changed in the submission following your feedback at the workshop. So firstly, we added some comments up the front of the draft submission to recognise the importance of environmental management and economic productivity being managed together. We've amended the comments relating to the proposed qualifying resident restriction to oppose this for plan making only, not consenting. And we've added participation in plan making as a key point in part 1 of the submission. We've also added a comment on the proposed permitted activity system to part 1, as this was something to highlight up front based on councillor feedback. We've amended some of the comments in relation to the natural environment to focus these on the ability to meet the goals and regional council responsibilities under the bills. So essentially the recommendations the submission makes in this area are to ensure the provisions throughout the bills actually enable the high-level goals to be met, and to ensure the goals, effects able to be managed, and regional council responsibilities under the bills are properly aligned. We've also made some tweaks to the points on Māori involvement to focus recommendations on obligations conferred on local government and Te Ture Whaimana. And following the discussion on regulatory relief at the workshop, we've amended the draft submission so that it no longer recommends regulatory relief be removed from the bills entirely, but rather states the council does not support the proposal in its current form due to all the issues we've identified, and seeks that changes be made to address. Next slide, please. So given that we had to work pretty quickly to get the draft submission updated and on the agenda for today's meeting, there are still a few minor tidy ups to the version that you have in front of you that will need to be made before it's lodged. These are all identified on the slide. Firstly, you may have noticed that there are some small numbering and formatting issues and minor typos throughout the submission, which we will tidy up. In points 86 and 87 in the planning bill table, there is a technical correction needed to the recommendations, just to seek that references to reasonable within these clauses be deleted, rather than seeking that the clauses themselves be deleted. Submission point 122 in the planning bill table needs deleting, as this clause relates to the qualifying resident restriction for consenting, which following the workshop, the submission no longer comments on. We just missed deleting this one point. I'll tidy up. And then the final one up there is just a typo issue, but because it's a little bit more substantial, I wanted to highlight it. So that is corrections needed to point 229. This recommendation is made in a few important places in relation to the bills, but has just been typed wrong here in this one submission point. So needs the corrections shown in red to align it with the other parts of the submission. We also need to attach the mayoral forum letter as referenced at the start of the draft submission. So we'll leave it at that. Through you, Mr. Chair, we're happy to take any questions.
Questions?
Yeah, Ben, just can you go back to the point you made just in your resident relating to him? Quite a bit of discussion, I think. In there.
I'll just find, it's mentioned in a couple of places. So we have added it as a new point, which is under part one, point I. So that's on page 42 of the agenda. And then we expand on it a bit more on page
65, item 104.
It also appears before that on page 49, point 60 and 61. So essentially what we've changed is the original draft that was before at the workshop didn't support the qualifying resident restriction for either plan making or consenting processes, and was seeking that that be expanded to enable all persons to submit. But following councillor feedback, we have changed that now to oppose it only for plan making. So seeking that all persons and organisations can submit on plans and plan changes. However, the submission no longer comments on it in relation to consenting.
Comment on
Other than say, would just be very clear at the difference, noting that you identify that in the comments that we might need to be about it. So we've referred to plan making, but we have regard to identifying that more. It's the very thing. Taxpayer and ratepayer of the person that provides structure of it, a natural person whose place of residence in the region, other than a natural person, district. So you recollect at the workshop where we went through the coastal plan balance and also couldn't take under the council said, hey, makes sense game making, but we want to make it tighter.
So does everyone get that? So in that case, we'll be amending item I on page 2, which is just the summary, to actually point out that while we want the qualifying person to participate in proposed plans, that doesn't apply to.
Yeah. The 61, and we'll double check back in the detailed table that we've got it right, because at the moment we don't think.
No.
So can we just poll, we have numbers on that, because being a commissioner and the whole idea here is just where and there's not and submit from anywhere, and you can absolutely they're talking to get some ballots. So I'm just concerned that do we have the number? Please. So means support.
Ask a question. Mentioned qualification as a person other than a natural person. Can you explain what it means, please? Yes, that's all. Only people who have got. It was a company that owned the property, they're not doing that. I think they need to be specific, because what they're trying to exclude is exactly what people have no vested interest other than ideology.
So, through you, Mr. Chair, just to help the type of folk who would be excluded from being qualified residents through the Plan Change 1 process. Be very clear, because I went back through the submitters and thought, okay, who wouldn't be a qualifying resident? And I went through the first 500 submitters. So who wouldn't be able to participate in the conversation, and around the table people will go, well, that makes sense, or oh no, we want them in, would be ACRE, Fish and Game, Federated Farmers, Port New Zealand, Farmers for Positive Change, Drainage Committees, Association, Hamilton Waikato Tourism, Resident and Ratepayers, Lower Waikato, Charitable Trust, Hill Country Farm, Port NZ, Lakes, Waterways and Action Groups, Farmers Groups, Catchment Groups, New Zealand Forestry Owners, New Zealand Grain and Seed, New Zealand Pork Industry, New Zealand Beef and Lamb, Royal Forest and Bird Protection Society, Institute Primary Industry, New Zealand Forest Managers. So those are the kinds of people who wouldn't be able to participate in plan making if we excluded them because they are not qualifying residents.
Yeah. On the face of it, right, that will be subject to challenge. As any change in the law, it is going to be challenged. This is the priest for lawyer. But there's easy way around. I can see it immediately. I put my name to something, Federated Farmers runs it, you know, or whoever, you know, foreign, you know, his name to it. Whatever. So there's ways and means. RMA is so a big deal. The reality is we want to get rid of this out.
So before we go to a poll, can we just clarify that we understand that what we're proposing is this relates to proposed plan changes, and it's not just normal submissions. So Tracy, do you just want to make sure everyone's on board and then we have a discussion about this before?
Yeah, Through you, Mr Chair, so there are certain provisions in the new bills that relate to notification of processes, and there's also the plan making. So those essentially are the two distinct matters. What the new bills do is put more emphasis on plan making equals participation in plan making, less emphasis on everybody being able to make comment on things. Vexatious or frivolous matters are actually outside this, because you could be a qualifying resident who's vexatious and frivolous. Those are matters to be determined by the hearings panel. So I would just put that to the side. What we're saying is for plan making, so setting up rules and the framework for consents to be applied for, what we are suggesting in the submission and what we got out of the workshop was those entities, advocacy entities, sector entities, NGO entities still be able to participate in plan making, but not in consent. That's where the direction was from the workshop. Councillors felt as though your federated farmers, your Hort NZ, not all councillors, I'll qualify this, forest and bird and your fish and games, residents and ratepayers should be able to participate in plan making, but less able to participate in or not participate in lodging submissions on. That's what we heard. If you want to change that now.
We've got a speaking order, so Warren first.
Yeah, thanks, Tracy.
Thank you.
Support where you're going there. We have a number of different types of plans that are relevant to different groups. I look across the coastal plan. You know, we've got all that coastal area, which picks up a lot of those NGOs, ENGOs, etc., that you've mentioned there. And it'd be a shame if someone like Robbie living out in the plains couldn't come and submit to our coastal plan. So I think that makes sense to me, as in who can be involved in that situation, and works fine. Yeah.
Chris. Good.
Keith? Yes, for you, Ben. I'm struggling, Tracy, because you know, having been involved in the PC1 process, became very, very expensive because people had to use the Knowles things. So they were driven by ideology rather than actually trying to sort the problem out. And so I think there must be another set of framing or wording that it will allow us to get the job done fairly and equitably without the nonsense that goes around the fringes.
Any other comments before we? Oh.
Yep. So I take your point, Keith, and I pose a question, Tracy, for clarification. So when you look at what Keith just raised around that, and it's discussed throughout the other parts of the submission around the natural environment and you know, and where they rank, and which I think is also important, you know. So is that also then part of that, to be part of that consideration? So because, you know, note within the submission, you know, you talk about ranking them more evenly, where the intent of the change the priority and the natural environment has probably a lower rank, personal property. So is that sort of interwoven?
Mr Chair, I agree there has been a definite recalibration of personal property rights as it affects the functions of territorial authority. Not so much for our regional council function. So I do think there has been a recalibration there. What I'm challenged with is when we're looking at things by submission point, I don't see the overall change that the government tried to make and that we are really supportive of efficiency of. And I think when you step back and you have a get that, it is still called a natural environment bill, not a natural economy bill. And that provides a bit of key that it is still our primary environmental management legislation. So I think that is key, and it is send clear signals around doing business within environmental limits. Actually, what some of those front pieces of the Act are saying, it is within environmental limits. It needs to be a more efficient, cleaner and less bureaucratic way of setting those environmental limits. And goodness gracious, all of us will be that. So I think it has stepped further to recognising the economy and environment are hand in hand, but it doesn't go far enough to put one above the other. That's my reading of it.
Thanks. I think this is a really technical question, and I just know Ben's probably going to do it. Massive thanks to everybody. I'm so disappointed. Still a piece of legislation that's longer than the previous RMA, and I'm saddened to hear that it doesn't seem to have that coherence of Tracy just mentioned. But it is just a mission going out. Others will make these too, and hopefully we need to keep moving. So I tend to move the.
Oh, we're not
Just
at that
put it on
stage
the
yet.
table for
Yeah.
later. Yeah.
Just wanted to clarify, Tracy. So you're going to clarify that it's the plan change, not the submissions process that we want the qualifying resident for, that you'll clarify that in the document. Consenting, sorry, yeah. Yep. Oh, are you comfortable with that? Just your mic, thank you.
Yeah, I'd just like a show of hands to make sure that we are, as a group, because there seems to be heads nodding one way or the other. I wouldn't feel comfortable if I knew that absolutely have a show of hands with a vote in the workshop. No.
Okay, well, we can have a show of hands on, Tracy, do you just want to articulate what the show of hands is going to be? Right. That's right. Those in favour, raise their hands.
Rephrase it because I'm getting some.
I don't understand. We need to.
I'm taking different things. So we want sector group.
Through to you, Mr. That's a little bit difficult to differentiate because I am a farmer, but I don't have the resource. So I call on federated farmers to represent me. But forest and bird, they have nothing to do with my farming involvement other than their ideological things. So that's a differentiation that we need to sort out.
For you, Mr. Chair, the legislation doesn't speak to ideology, and I totally appreciate where you're coming from, but the legislation doesn't say, well, we'll have these people who ideology is aligned here and maybe not as aligned here. It's very clear you're a person, you're directly affected by something next door to you. Should you be allowed to participate or not? I think we're all agreeing that yes, you should be.
I disagree in that because, like, if I'm backing on the copper peat dome and you're going to do a plan change that's going to take half my property away, I don't want everyone else having it participating in that. It's me and the landowners around it that should be arguing the point. So obviously you should stick to being a President,
Resident.
yes, so I.
Okay, well,
Mr. Chair, can I,
Mr. Chair.
Yes. Chris.
So, Mr.
yeah,
Chair,
can I suggest way forward? He's been involved in this process. He understands the frustrations and the dealing with this. Tracy has as well. I'd like to see them sit down and nut something out together, circulate it, and we can say, yes, that's. Because I just don't, I'm with Robbie on this. I think it's the people that are directly affected by decisions that are going to be coming out of the tribunals, who might be, they're the ones that should have. These fringe groups have had, you can see what's happening down the South Island now. They're trying to stop that. Even the fast track legislation, being frustrated while people have got no vested interest, apart from some lizards falling back door. So I really think we need to finesse this better than opening it up to.
Yeah, but we don't have time. This has got to be submitted by the 13th. And also the point that Warren was making is that with the coastal plan, it would prevent most of the fishing groups and things because they're not qualifying residents.
no,
They have to live in the area.
coastal area for the region. So I would be, as is Robbie, as everyone else in the room, the coast is something that we utilise from time to time.
But it
Yes,
wouldn't
so-
necessarily be the agencies. For example, Aquaculture New Zealand, for example, would not be submitting
It's different.
because they weren't a qualifying resident. Yeah, the agencies wouldn't be.
Yeah. They're a business that operates in the area. Business that operates in the area.
No,
So
they're not.
yes,
Through you, Mr. Chair, they are not a business, they are industry entity.
ways and means having certain panels, get representation table. Somebody is front and you fund.
Through you, Mr. We know people be one of these.
Okay, so maybe we can take this in two parts then as a poll. So firstly, do we, sorry.
I don't know,
yes,
Mike Tracy.
no.
Tracy, is this not open to the public? I'm really sure I saw
Yes.
email come through from one of the government departments to say, this is open now and it closes this date. And it didn't say you can, you can't, whoever. So why are we trying to differentiate around who can and who can't? If they themselves have made it quite.
Yeah, so the putting on these bills totally open to the public. Why we included this in our submissions is because we value what we really value what some of the experts bring to the processes. It's not always a perfect process. I fully agree with that, but we value the expertise and the knowledge that some sector groups, NGOs and others bring to the table that you otherwise wouldn't get through individuals. That's why we raised it. Also, just as an aside, we had about 4 or 5 of these entities say, crikey, thanks for pointing that out. We totally missed it. It would mean sterilise our ability to participate, and that wasn't from some of the NGOs, it was. So they will have their own point of view. It may not be what we think, but we.
Okay, we've got 2 more and then we better go to the poll. So Chris.
Yeah, look, I hear what you're saying about time, and I agree. It's tight time. That's no excuse not to get to it. In our submission, I honestly believe you're incorrect. Time shouldn't determine that. It should be.
Jennifer?
I think a poll might be okay, but I guess I'm just saying there was a lot of confusion about what it does mean. But I like the proposal that with that for something really high level, a lot of people can, including the NGOs, something that's really close to home. You have the landowner worry about that. and not have extra yes, Arjo. I think it's a really good round. And at the end of the day, it's our submission. Proud of it, absolutely. A submission. I had lots of jokes before about other submissions they're getting and how much.
So I'll just get Tracy to articulate what it is we're going to poll on, and presumably if we don't vote for it, it gets removed from our draft.
So I would suggest through you, Mr. Chair, that we take it as you said in two parts. One, the qualifying resident as it applies to renting processes. Agreement or agreement that presently our submission is silent, but that's because the proposal says you have to be a qualifying resident to participate in the consent.
So do you want to articulate what we'll vote on that one?
That we support it, the bill as drafted.
Okay, all those in favour? Aye. All those opposed? Carried?
Okay, and
Post.
then
Opposed?
Post.
Then what we had in the submission at paragraphs is that qualifying resident, i.e. the resident ratepayer of the district that also applies to plan making.
That's good.
You have to be a qualifying resident to participate in plan making.
Leave it our submission. Is that the question?
Yeah, that should be the question.
So can I take you to paragraph 60 of our submission on page 49? Thanks.
Yep.
We are saying here is we like.
So we're either voting for this. So at the moment, we're saying the council does not support proposed restrictions on standing, limits submissions on proposed plans and changes to qualified residents. So we're saying, yes, we agree with that. No, we don't. As this prevents groups that represent relevant sectors from the community from participating in these processes. That's particularly important given the reduction in participation at the consent.
It's an assumption.
What's a logical assumption? So, yes.
Yeah. Sorry, Ben, through the chair, could I get a point of clarification, please?
Yes, Tipper.
Oh, no, it just, I'm not sure, it's stated in the double negative, so I'm not sure how to vote.
Okay.
That confused me.
Spot on.
So at the moment, item 61 follows on from that. It recommends removing the requirement that only qualifying residents can submit on proposed plans and plan changes.
So we put it simply, do you support excluding people?
Well, we can just stick with this. We could, do you support our recommendation to remove the requirement that only qualifying residents can submit on proposed plans and changes? It enable all persons to submit.
Simple.
Okay, all those in favour? 3, 4,
Aye.
7. Those opposed? 5. Carried. So that remains as our submission.
That everybody participate, sorry. I'm just being really clear. Sorry, Ben.
Yes, that all persons and
Yeah.
organisations can submit on proposed
Thank you.
plans.
No, thank you. My apologies.
Cool.
Okay.
Okay, moving on. I had an issue here that I wanted to raise, which is in relation to regulatory relief. We discussed that in detail in terms of page 47 and set out why we're concerned about regulatory relief, but we don't note it at the beginning of our document. On that.
No, that's probably just an oversight and speed of drafting of the submission so we can move, give it more significance at the front.
You just want to talk about what says about legal. So,
So, Miffy outlined, perhaps actually I'll pass over to Miffy.
Okay,
Just
so
note the point, Ben.
Yeah, sorry.
Paragraph 44.
so you just want a quick summary of what it is?
A quick summary of what it is and where we landed at the workshop.
Okay, so the bills require councils to establish a regulatory relief framework within their plans when they're proposing a rule on a specified topic that is reasonably likely to have a significant impact on the reasonable use of land. So the specified topics that regional councils are responsible for under the Natural Environment Bill are significant natural areas, sites of significance to Māori and terrestrial Indigenous biodiversity. So once the plan becomes operative, councils must then implement the regulatory relief framework, and that might be actually paying the money, it might be rates relief, it might be some other type of funding or discounts on consenting fees, those types of things. So originally the submission that came to the workshop, we had opposed it outright because of the difficulty in like the administrative burden, our ability to actually finance it, those types of things. At the workshop, we discussed that the intent probably was valid. It was just the way that it was proposed in the bill. So through the submission, we are suggesting some changes to modify the proposal. So what we're suggesting is that where areas are already identified in existing plans, where properties have already benefited under other mechanisms such as grant funding or other types of monetary or rates relief or something, where there's potential duplication under land use and natural environment plans, and where local government is directed to include provisions in plans through legislation or national direction, so the government's telling us to do so, or we're required to do so for treaty settlements. We're saying we shouldn't be required to, as the local council or the regional council, to have to pay for that or manage that impact.
Yeah, so it's quite significant that we could be up for liability even for things that have happened in the past.
Yes.
So
Yep.
it was an important point to raise. So we've got Robbie, you're off. Noel, you still speaking?
On this, and those of you who have seen the draft that there's a suggestion that 4,000 hectares be retired. Soil erosion and et cetera. So this could come under that potentially, and therefore, it's been suggested in up to $1 billion of compensation required. But it just opens a can. Worried about the on my pain at the moment. I've talked about what this is. Like if councils are deficient and negligent or whatever in doing their work, fair enough. There's some but where it's don't want to see that situation getting used other.
Gary.
Yeah, so I think it's a good point and covers 37 and 109 as well. I think they're all sort of tied together. My question being around this is actually who pays. So the assumption is it falls back to regional councils and local councils. Is there a possibility or is a case, if you take the Whangamarina as an example, that if something like that happened, that'll become a national, it's central government rather than us who pays?
I don't think so under this regulation. So, yeah, sorry.
Mr. Chair, that's a very valid issue. What the provisions presently say at the moment, and as Miffy said, central government could direct us to do something. Remember, I tested at the workshop when somebody said we should just be doing what the government says. If we get a change of government and they may direct us to protect every wetland greater than X amount, and that's a very clear directive, then it will be the ratepayers who will have to cover that, not central government. And we also said, when you look at that under our rates cap, there are real challenges there.
Because it goes wider than that, doesn't it? Because when you start thinking about that, then if you want to start talking about issues around climate change, you know, retreat, things like that, and it just blows right out.
I think our submission is really good on this. It was just, I was hoping it would be highlighted up the front because it's one of the key things. And maybe this is what Warren and Chris McClay will submit on verbally, that it's a key issue for us. So, okay, everyone happy with that? Warren.
Yeah, no, I'm supportive. I like the way you've picked up what you did here at the workshop, and that's been articulated. There are some real dangers in this, so yeah, very much.
But another issue I found is that in the very front of this document, we have item H, which talks about resourcing the changes and permitted activity systems. I'd just like the permitted activity systems to be broken out as a separate item because it's quite significant. Do you want to talk about that as an issue?
Yeah, look, I think it's acknowledged it was just a matter of brevity. We thought we'd put the two together, resourcing the changes, because this really is a bit of a when a gift horse is a Trojan horse, the permitted activities, because we can see that it's going to be a very resource intensive part of the process. I think Councillor Smith in the previous item talked about rearranging the deck chairs, and this is one where we are anxious about a system that's created that's called permitted activities, but actually it's going to create some more bubbles of resource in the system. So I think definitely worth separating those out.
Yeah, essentially you were going to have a notification of every permitted activity, which was then going to impact on workload and timing. Gary.
Can I just raise up a matter?
Yes, absolutely.
Yeah. So then I'd like to go to the front of the part 2. Okay. Point D. Get that removed. I don't like that.
Okay, so this is page 43.
Yes, 43.
Item D. This item D showing up on the
Also, we talked about it just a few minutes ago, also around hierarchy and things like that. So, Bill, you know, our submission is starting to talk about changing hierarchy again, and we. So yes, I get it. It's about we are about trying to improve our productivity and go forward to the region, and if we start suggesting that we're going to place one over the other, I'd remove it.
Yep.
So I think just to be very clear, this is talking about the instrument of a natural environment plan. It's not talking about placing the natural environment above land use. It's saying the 3 plans that we had, which were there's a regional combined plan, which has a regional spatial plan, natural environment plan, and a land use. What we're saying here is the natural environment plan, which we don't determine, it's determined in legislation, with a lot of that coming from national instruments. That needs to go first for the land use plans. So it might be words here, not around hierarchy, but the sequencing of when these things get developed. Because to develop a land use plan without having those environmental limits defined in what is called a natural environment plan means you're going to get out of sync, and you will enable, you will either enable or disable a whole lot of growth without having the evidence of whether you've got things to support it. So it's not around hierarchy of natural environment, it's around hierarchy of the instrument. You wanted.
I was just going to add that it's a risk that we've identified that you've got a planning bill that talks mostly to territorial authorities, and then we've got a natural environment bill that is more regional councils, and I acknowledge that they may not exist in those forms in the future, but at the moment, with that separation, there's a risk that decisions are made on land uses that result in breaches of the environmental limits, which then becomes an regional council responsibility to manage. So it's just making sure that when those decisions are made on under the planning bill, that they are cognizant of the environmental limits so just trying to link those responsibilities so that decisions made over here don't jeopardize decisions.
It's just the wording that
Yeah.
is
Yeah, we
amending the
can-
plan hierarchy, which is much more significant than simply the sequencing.
So could we say, I mean, the plan hierarchy is actually set up in the Act. We don't call on that, and
We
we're
are
not,
making a call in this
Well,
submission then, aren't we?
we are saying that in terms of the hierarchy, yes, sorry, we are. In terms of the hierarchy, we need those environmental limits set before you start saying you can have these kind of activity here. Otherwise, we will get proposals. Say one of the environmental limits we're looking at is around land susceptible to climate change. So we could get land use plans that say, we'll happily support another 500 houses here without the environmental limit. Say, actually, this is an area we should build, either a floodplain area. So we could change the word hierarchy to sequencing so that the natural environment plans are prepared prior to land use plan.
If I could just add something through you, Mr. Chair. It's about sequencing, but I think there does also need to be another word, and hierarchy may not be the right word, but something to create a link, because that is the problem at the moment, that we have both bills establish a hierarchy with the goals of the bills and then national instruments and then the regional spatial plan. Under the planning bill, land use plans come next in the hierarchy, and under the natural environment bill, natural environment plans come next in the hierarchy. However, there's no linkage, and both of those currently get developed at the same time. There's no linkage between them to require territorial authorities to consider the natural environment plan. So that could mean that they are developing plans that provide for development that may result in a breach of the environmental limits with no requirement to consider that. So the word hierarchy may be too strong, but something that requires the natural environment plans to be developed first, and also for territorial authorities to consider or have regard to or something, those plans, so that it's not setting it up automatically for those environmental limits to be breached, which regional councils would deal with.
You've got Warren, Ben, Mike, Gary, Kramer.
I'm happy if Gary's questions carry on.
Mine was a carry on to an extent and covered it, but it's probably for a bit more clarity. Because point C, which I really support, and I think it's a good point, and good point B not be they're two different bills. Does point C not give you joint thing added in there at all?
Streams here, I think D is making quite a different point, but I do like what Trina's saying. It's around the linkage and sequencing. So perhaps if we use those words, we'd get across the same message. But yeah, I am.
Warren.
Yeah, Katrina, can you help me understand just point 71, that's on page 52. We seem to be wanting to insert some a clause or something in there for future climate adaptation legislation. Not sure what that's actually asking for, and how some future legislation could somehow affect this.
Yeah, so the reason that we've asked for that in that way is the bills are reasonably silent on climate change and climate adaptation matters. And the reason that we decided to ask for a clause that refers to that future legislation is because the government has strongly signalled that that's coming, and that's where they want climate adaptation matters to be dealt with. So we thought that that was probably a simpler way to request what we want, rather than having a lot of different submission points that seek climate change be inserted at various places throughout the bills. So we're just trying to, with that point, convey it in, I guess, the simplest, clearest way possible, that it's really important that if the government want adaptation dealt with under a different bill, that these need to integrate really well with that.
That connection again. Yeah. Okay.
Mr.
Thank
Chair, if I can clarify, because it was raised at the workshop too, just me to the side. This isn't kind of crystal ball gazing what might come in terms of legislation. Government has said that it will look at the start of our next financial year to introduce the legislation on the Climate Change Response Act, and there are specific responsibilities there for territorial authorities and regional councils with regard to priority areas that are exposed to climate risk. So it was saying, hey, rather than wait and then have to do an amendment, get it in now, as Katrina said, put it somewhere quite generic, but at least provide that link. So it was legislation that we know is coming in.
Yeah, that is strongly indicated. Yeah, I've seen that. Yeah.
And then Miguel.
It's been answered.
My concern, like I brought up in the workshop, is probably 49 and 50 on 48. Just the massive cost that this could bring, Tracy. You know, could it be more reaffirmed in there? Because it depends on the makeup of the CTVs as well, you know, because I know, you know, our area will have a lot of those SNAs in them. And, you know, I'm just afraid that, you know, it's going to put a huge extra costs on whatever the CTVs makeup's going to be.
Through you, Mr. Chair, look, I think that's something that we should highlight, that connection of the CTBs, the connection of the rates capping, the connection of these additional responsibilities. I think, Miffy, at the workshop, you said there's 22,000 individual parcels.
Yeah, around 20,000.
Around 20,
Yeah,
embellishing.
but there may be, that's identified regional council, so there's also ones that are identified by the territory.
I think just in regard to the costs, those of us who have lived through the transition from one planning regime to another, it's those transition costs that are huge. And just highlighting that's important.
Yeah, just on that, I think that regulatory relief is something you will be raising in the submissions directly with government as a key issue.
Yeah, through the chair. So just for those councillors who are unaware, once we lodge a submission, we will indicate we want to be heard, and we will have an opportunity to be heard in front of the Environment Select Committee. We are given 10 minutes, so it's not a lot of time, and we learned last triennium the committee don't really want to know the special, unique quality characteristics of the Waikato region. They want to cut to the chase. In a number of matters that we presented, we say, here are our top 6 points, and here are some very clear examples. One example that we will likely highlight that hasn't really been discussed will be Lake Taupo. So the government, iwi, ourselves, invested around, and I'll embellish again, I'm going to say 76 million-ish. Into Lake Taupo to implement the regime around Taupo in terms of the nitrogen trading. Now that has been very successful. It didn't come without challenges. It hasn't come without pain. Everyone acknowledges that. What we need to say and what we will be saying is, hey, like what you're doing with the Act, but actually you might cut across this. And that's $76 million of Crown money, essentially public money down the drain. So that actually carries more weight, more cadence with the select committee than going through very technical points.
Fine. Just moving back to that, amending the plan hierarchy, that item D earlier, just further in the document, what have we stated about the plan hierarchy? What wording is it further on, so that gets amended as well?
We will pick that up, Mr. Chair. Any amendments that we make to the front, we will go through and make consequential amendments in the detail. Again, this is one that the chair and myself will sign off by Friday. So, yeah.
Any other questions or comments? All of it? Oh, Keith, sorry, you and Mike. Yeah.
And if you could give us the submission number.
Yep.
Reference, that would be really.
1273 interpretation. So my concerns is that you've sought clarification to add in geominerals as opposed to just minerals and water. But because of our peculiar situation in the Waikato.
Sorry, could you just let us know which bullet point where you're at down there? Okay. Page 72, is it?
Yep.
71.
Then goes down to 72. Yeah.
That's the second to last bullet point. We recommend the term minerals be replaced with geominerals. Is that
That's
right?
right.
Yep.
I would like that to be opened up to include the issues that we have in the Waikato of biological induced things like peat tannins, forest litter, which is discoloration, and clarity issues we have with microparticles in the soil from the soil from volcanic activity. And on top of that, I would like to add in the issues that we have with pest factors such as koi, carp, and Canadian geese, because they all affect water clarity and features in our water which are peculiar to our area.
Mr. Chair, I understand what you're identifying, Councillor Holmes. We're not talking about the source here. So we're not talking about whether it's a duck, a fish, a cow. It's the outputs that are in the system. I understand what you're saying, the naturally occurring outputs, but accounting for those in the system. But I think things that are not naturally occurring would be a challenge to put in a definition of an act. A real challenge.
Through you, Mr. Chair. If we don't front foot this, Waikato will always be on the back foot in terms of meeting national standards and that sort of thing. So we need a mechanism to acknowledge that the state of the water and some of the causes for the water which are not man-made. And that's, obviously I've got a farming background. That's something that's of major concern.
Except I think this is in the definitions part, isn't it?
Yes.
We're defining what the terms are, not, yeah, so unless there's another definition you'd like to make, it's just widening minerals to replace them with geominerals.
So this is in the definition sections of the Act. Now, Crown Law will go over this like nobody's business because this is where everybody goes. Only too mindful of what you've said there, and again, hats off to Brent and the Rudd team in getting the change that we got through government to take account of some of these matters that aren't man-made, i.e. the sedimentation in the Waipa meant we did not have 2,500 farmers requiring consent.
Yeah.
So we're very acutely aware of it. But I don't think this is the right place to address it. But I do hear what you are saying. But as a definition in an act, stretching out to some of those other things might be a bit of a...
May be available somewhere else in the mission, just not in that particular part.
Okay, so I accept that, Ben, as long as we acknowledge that, because what you're doing is you bring in the fact there's mercury in the water from further up the river and that sort of thing, but there's other contaminants coming in that we don't have any control over.
Anything else from you, Keith? Oh, on any other issues? You had quite a list you sent me through, and we've dealt with many of them. Very well worked. Come back to you. We'll go to Gary Maguire in the first place.
Just backing what he's saying, and I see where he's there with issues with geese and so coliform maybe rather than go into that detail, adding some minerals and organic, just something so that it opens the door for that to be questioned rather than going right down to the point of itemizing what it is, but just the word of contaminants.
Yeah.
Sorry, can I just jump in and say, so the term mineral is only really used in the planning bill to help define what natural and physical are. So it's got quite a specific use in the bill just to help identify those natural and physical resources that need managing.
Yeah, just to add to that, so I think as Miffy said, mineral is used in quite a specific way. There is also a definition within the Natural Environment Bill for contaminant, which I think might be more where your comments go, which is a much wider definition.
You want to draw us our attention to where that is?
We have put it on that. I don't think is as defined is pretty much taking the same definition of the RMA, which has been well tested through court. I can read that out. Yep. So contaminant includes any substance, including gas, odorous compounds, liquid solids, and microorganisms, energy, excluding noise, and heat that by itself or in combination with the same, similar, or other substances, energy, or heat. A, when discharged into water, changes or is likely to change the physical, chemical, biological condition of the water. Or B, when discharged onto or into land, into air, changes or is likely to change the biological condition of the land or air onto or into which it is discharged. Crown law or but it's a very detailed definition. It's a definition that underpins the management of the natural environment, and I think the point making Councillor Hone picked up in the process where we have to define environmental limits for contaminants.
So I'm just coming there, Tracy, through you, Ben, is that the key word is discharge, and that in terms of legal interpretation, that means that somebody has done it. What the point I'm trying to make, this is already in the water. So that's where it's going back to what you're saying, is that we don't have any control over that. Whereas a lot of the water regulations are basically is trying to control the discharge, which happens by man's interference. But do you understand the difference there?
And there is a definition of discharge. And there is a definition of environmental health. And I really understand the point that you're trying to raise. I just don't think it is able to be addressed in the definitions part. And I think it's more comes through the process of setting the environment.
So we're at 12:30 and we're keen to move along unless there's any other major issues people want to raise. Harry.
I've got two more, please. Page 114.212. Just a quick question around that. It seems like seeking to capture potential to have PC1 legislation back in force back into the council, whether the RMA changes or not. And the other point I'll raise it straight away. What here? Then you can.
Firstly, can you just define what it was you were saying in 212? Because it's now up here for people to see.
Okay. Yeah. It just seems like you're trying to capture a lot of the old RMA stuff, that what the council could and could not do, and bring it back into council's own. So protecting your patch rather than saying we actually want to. Just trying to capture too much control back to legislate.
it's definitely 212. That is in fact trying to safeguard council liability, potential liability. What moment is very related to a land use. What we're saying is that should be extended. The power to decline approvals should also be extended to regional permits, back where they are related to risk from natural hazards, not all the, which I think is your question saying, hey, is that apply to everything? No, it is still a vision of where things are related to natural hazards. We still should have the ability to decline if any of those matters that we have at the moment responsibility for, and we believe that there's risk from the further enhanced, we should have the ability. So it's not open carte blanche, it is just.
And in point 240, just an amendment of maybe, so the point where you go down to the community assistance, human health, which are, and I'll leave it at that, or maybe, because or maybe is too loose, then it just leaves it very open. Let's go and then otherwise I'm happy.
Well, speaking of happiness, lunch is probably here now. We have a number of other items to get through. We've got the infrastructure funding development levy submission, which is relatively rapid to get through, but we do have submission summary report and the regional coastal plans appeal. So the question is whether we want to break now or push on to 1 o'clock and try and get through.
For you, Mr. Chair, I suggest we at least finish this off by minimum.
Oh, absolutely. We'll get this one done. Yeah.
And then open to,
yep.
Yeah.
Right.
I can eat, don't mind cold ham.
No, that's fine. So, are we ready to wrap up our resource management submission? Okay.
Can I just say that when I was in the justice, there was a saying, laws are made by lawyers for lawyers. This smacks of it.
Thank you, Noel, for that wise aphorism. Okay, so Jennifer, you had moved this originally. Can we have a seconder? Sorry, Keith.
No, I'm not seconding. So I just want to bring up, and I know it's a little bit out of context, but page 84, 225, talking about permitted activities. And within this, there's a mention that permitted activities must be notified. And what I'm concerned about is what traditionally was a permitted activity could actually become a consent by subterfuge, the way it's being worded in the RMA. And I think we need to get clarification on that so that there is a permitted activity is self-management, not another thing that the has to step in and
For you, Mr. Chair, I think that's a key tenet. Another one of these things that a permitted activity is quite different to a permitted activity. The whole framework around managing those permitted activities, and for us, it's really confusing as it's written at the moment. Not only for the poor teams that are going to have to interact with people who are coming in thinking it's a permitted activity. What I've always had is a permitted activity. Now is a permitted activity, but with a raft of bits and pieces associated with it. Mark, is there anything you wanted to particularly add there as kind of somebody with decades experience? And you'll need to pop the mic on.
Yeah, from a implementation point of view, and that's the part of the regulatory part of the organisation, sit here representing a bit today, we're quite concerned about it. Set out already. I think it's quite fair enough to describe it as a consent by subterfuge when you have to register a permitted activity. The council then has to record it, administer it, respond to it in terms of whether it will apply. Some permitted activities have technical certification requirements coming with, which really mirror what a consent process is about. And then to add to all that, at the end of it, we have to monitor compliance with the permitted activity. Or you might as well not call it a permitted activity. So we are quite concerned about it. It does seem to fly in the face of the overall thrust of the legislation, which is to make things simpler, less bureaucratic, straightforward. So,
I think
yes.
we've covered that quite well in the submission. So, yeah. Thank you, Keith. Anything else?
Pages now. No, that's it. Sorry. Yeah,
Okay.
no.
Tipper. You wish to comment, Tipper, or you just wish to second?
I was just seconding the rest. Thank you.
Thank you. Okay. Well, all those in favour? All opposed? Thank you, staff, for a very detailed and exhaustive process, and done well to get here. So there's not too many changes we'll sign off on, and we're all good to go.
How much do you want to put up?
Okay, so now we want to move to the Infrastructure Funding and Development Levies submission. Advisor Paul Bowman.
Sorry, Mr. Chair, just quite a few words from me. This is not one that we workshopped, so hopefully you heard it. It is fairly straightforward. We'll cut to the chase and identify those matters, but being that we've had two substantial submissions that we workshop, we didn't bring this one to a workshop, but hopefully it's straightforward enough for you. Over to Paul.
This is page 148 onward.
129.
Yep, 129.
Oh, right, starts there, doesn't it?
Sorry.
It's straight.
He was jumping to the actual submission, so.
Good. Thank you, Tracy. Thank you, Mr. Chair and councillors. Good afternoon. It is afternoon, so I'll be succinct as possible. As Tracy mentioned, these are two separate but interrelated bills that will hopefully give us, or whoever's responsible for the function of providing infrastructure, the tools necessary to assist with funding. I'll briefly explain. The first one's basically been on the agenda for many years, not just with the current government, but previous governments, to replace development contributions with a development levy tool. We're very supportive of that. Development levies, in short, allow the responsible authority to charge across a broad infrastructure area to recover aggregate growth costs, whereas DC is always generally tied to site-specific improvements. So this is big picture stuff, development levies, and you can charge for infrastructure, Three Waters infrastructure, community, and critically transport infrastructure. Our submission, like I said, is pretty much saying we support it, and we'd also like to be able to use it as well, please, because DCs are primarily focused on TAs. TAs use DCs. However, it's still interrelated to regional council growth management, especially around flood management and drainage and catchment management costs that were discussed earlier. And I know this was brought up earlier. It was a bit glitchy. I was listening online, but I think you discussed how do you pay for all this, and there's a current funding review going on, as Tracy mentioned earlier as well. So I think the development levies is a good thing. Our submission looks to be included, as it says up there on the left. We could potentially identify where this could be spent, public transport wise, but really on flooded drainage schemes, very relevant at the minute, what you see going on all around the place, around flood defences and the costs of managing growth. And that's the key thing. Development levies are to capture the costs associated with growth rather than renewals. So it's identifying the growth through future regional spatial plans. Regional spatial plans, they basically look at where growth goes and the funding and financing through the Pillar 2. The government wants to clearly see a link for how you're going to fund that growth. And so they're making available the use of these two tools. So like I said, supporting that would like regional councils or whoever takes over the function that was discussed previously to include us. And so we can use levies as an additional tool and reduce the rates burden and the ratepayers who currently shoulder pretty much the bulk of the costs the regional have around flood defence, flood management. That's development levies. It's a succinct overview. It's a draft bill, so there's a discussion document included with the report. Goes into a bit more detail about levy areas, how you identify a livable service area. So you might have multiple levy areas, one for infrastructure, one for transport, one for community. I think one of the snags is, as we all know, planning doesn't neatly stop at a hard line on a map, and flood erosion and flood defences often cross TA boundaries. So we've just flagged that in the section to say we'd like wider catchments to be looked at in terms of downstream flood costs and how we recoup to manage a level service to support growth, especially in the brave new world we find ourselves in through regional planning. Moving to the second one, slightly confusing, but very similar title. Infrastructure Funding and Financing Act's been around a while. It's been around since 2020. Hasn't really been used very well. There's an example in the report. Tauranga City Council, sorry, Western Bay of Plenty through TCC used it for their transport network planning. So basically this mechanism allows the debt to sit off council's books, really, and you go through a special purpose vehicle or SPV, and they usually carry the debt, and they look to refund it by, again, charging another levy. Could end up with having levies in the future, but they target levies across the area that the SPV is in charge of in many ways. So again, much like the first submission on development levies, we're saying we'd like to broaden the eligibility for use of those tools. So the legislation on the Funding and Financing Act does that at the minute. The government are actually widening the use of that tool for NZTA, Kiwi Rail, CCOs, Three Water CCOs. So they've clearly got an eye to the future in terms of things like Waikato Waters, AOI taking on some of these functions. So they're broadening the mechanism to be used by others, although we're again saying regional council function should be captured by that mechanism. And then the only other thing to close out is one of the key changes they've suggested in their amendments to that bill is when you charge a levy through an SPV, providing the costs are accepted by the landowner or future landowners in that locality that you're seeking to charge the levy, then there's no longer an affordability test required, whereas previously there was. And we'd just like a bit more information on that, given the fact that you've got rates capping. A lot of existing regional council ratepayers shoulder a lot of the burden of asset management for growth. And so just because the identified future landowner is happy to sign something saying they're happy to pay the levy, I guess we're kind of thinking a bit more long term, 10 years plus, how we look at that sort of affordability capture. And again, it was mentioned a bit earlier this morning, probably seems like a long time, but there's that piece of work ongoing by others in the organisation around the funding review. So I think that's that other place on that submission. But yeah, in short, we're supportive, would like the ability to use them as well, or whoever has the responsibility of going forward under the new post. And also we're just identifying a few cross linkages with how they're actually used and how levy areas are identified in future regional plans. Make sure they also and transport plans as well.
Thank you, Paul. I think we've got it. We've got it. Yep.
Done.
So they're basically very simple. You're basically asking for us to be included in the process. Jen, you got a question?
Questions. So because they were joined together, I got a little bit. But so both are linked to urban growth, right? And so it's not really that relevant here in our region. That's rural parts.
Yeah, yes, and no, but you're right. They are linked to urban growth. I guess one of the key issues we have is it largely depends where we are in the wider region. But obviously, one of the key issues we have is there's downstream costs managing urban growth that might happen in the sort of the bigger city TAs and so forth. So it's where that again that line's drawn and level of service that we still have to provide.
And I totally agree with the mission points and everything. But administratively, would a development levy or a funding vehicle be the same as a type? Or different?
Slightly different. They'd sit off the council books, so it's kind of moving chess pieces around on the chessboard, but it allows you to free up targeted rates for other things because the debt sits on a special purpose vehicle.
Right.
But no.
Your focus on that, but I note on page 1, flood protection infrastructure. See that they don't. So for me, boundary of the urban area out, urban rural. So can we make sure out of chance that drainage?
Yep. Fine, Warren.
Yeah, thanks. Is it worth putting something in there that around the rates capping legislation that we've seen? Totally support us being able to use these tools. I wonder whether there's a constraint probably around that rates capping and whether there's a comment.
Well, are you suggesting we can call rates levies and?
Well, there might be a loophole. Yeah. Who knows? But
is that complex to add in or not?
No, I think we mention it in the report in the conclusion that this is even more important given the proposed rates capping.
Tipper online.
Just to help with my understanding, could you, the report writer, explain it as if we apply this to a Lake Waikato type solution going forward as critical infrastructure? What you're proposing we're submitting on?
You're aware of Lake Waikato and the issues there?
I'm not, I'm afraid. I can.
Tracy, would you like to summarise?
Tracy, I'm trying to figure out our net benefit from this approach in terms of a Waikato solution or something like that on scale. What we're saying? Or it will have an effect. Zero effect is cool too, but I'm making a huge assumption that this can cover that.
Sorry, can you hear me, Tipper?
Yes, I can.
So how I would view it is, at the moment, our local councils can take development contributions, thinking for development in Te Kaupata. They're able to take that for the impacts of growth. The impact that growth may have on the area like Waikato and other areas surrounding Te Kaupata, and the contribution that growth may have to some of our challenges. At the moment, we are unable to take a contribution from the generators of that growth, the developers. Therefore, the costs fall on our targeted ratepayers or our general ratepayers. This is really just another tool in our Swiss Army knife of exacerbators and who should pay. So we may not choose to use it, but it is
Mhm.
it may be a tool where we can directly attribute an effect back to a developer, and at the moment, we can't take a contribution.
No, thank you. Appreciate the applied example. Helps me. Thank you.
Thank you, Paul. For submissions on both, the two submissions look very similar in terms of their wording and names and etc. Okay, so can we have a mover and seconder for the recommendation?
Mr. Chair, it will be a B because we've got to make the alterations
Yes.
for drainage to incorporate that. So,
Okay.
again, it's another.
Happy to move.
So, Jen?
Happy to move.
And Jen. Okay, that's fine. Okay. Thank you. Murphy, we've got the submission summary report.
Yes,
Can we take it as read?
absolutely. So
Okay.
this is something that will come every time, and if you've got any questions,
Fine.
take them, but otherwise take it as.
Fine. So can I have a mover and seconder? Jen? Liz?
Chair. I just want to point one thing out for our new calendar. On page 105 of the agenda, as well as page 166, you'll see a couple of maps. So they are really the guts of the report. So we are making submissions in your constituencies. You will get this map updated every 6 weeks. And also on page 166, which is our fast track applications. We have the most of any region in the country. Buffy and the team are doing a fantastic job of responding to these. When we made our submissions, we said there's going to be a whole lot of extra resource, unfunded mandates, and Miffy's team have just been responding. So those 2 pages, 155 and 166, are really important reference.
And very appreciated as well. Great, thanks.
Good. Okay. So we've got a mover and a seconder for the submission summary report to be taken as read. I'll move. We have a seconder? Liz? All those in favour? All those opposed? Passed. So we're now onto the retrospective receipt of the submission on the targeted rates model. If you've had a look at it, it came out in the addendum, and it's a really nice submission, given that we weren't even supposed to be able to submit to the rates form. It talks about the zero emission buses and the costs that will be included in them, and how we'll struggle to keep within a rates cap band when we've got infrastructure upgrades and stuff like that. So it has gone already. So it's simply a matter of noting that it's been and gone. So would someone like to move? Heath, second. Kata. All those in favour, please say aye. Opposed? Passed. So we're now in a resolution to exclude the public. Seconded. Liz. And if we can get into excluded. Pass that. Carry. All those in favour,